Good morning, everyone. I hope everybody can hear me. Um, I'm going to start in a few minutes, but customarily I give it about 5 minutes before I formally start to allow any late comers. Can I see some thumbs up for those that can hear me, and thumbs down from those that can't, or just nothing from those that can't? Thank you. That will do. I'll start it exactly in about 4 minutes at 5 past, just to allow latecomers, not to punish those that are on time, but to just take everybody on board at once. I'll also share the slides, which I hope you all got on the screen in a few minutes. Thank you. Okay, let's start. Just to be sure, does anybody, is there anybody who doesn't have the slides that I sent you or that are made available through lead? I'll assume that everybody has got, and therefore that we can start. But is there anyone who doesn't have?
Mr. Kashana, I've sent through the slides to all the delegates, if they can hear me. Those that registered this morning, their slides are going to be delayed.
Okay, but everybody will have the benefit of the screen. Am I sharing? Is it showing on everybody's screen? Barbara, I'll still use you. I just want to make sure if everybody has got the slides on the screen. Maybe I'll assume that everybody has, unless I hear from anybody. Let's start right at the beginning with introductions, if it's necessary. We are scheduled for 3 hours. I thought probably we will take a break around 11:15, and then probably a short break just after 12 o'clock. But we'll play by ear as we go. For now, let's just agree that we'll start and try and finish the scheduled work as appears, or as it appears on your slides. As I've mentioned, let me just try and get out of this so that I can. My slides doesn't want to move. I don't know what's the controls there. Okay. Yes. The first slide there, I'm introducing myself, Kashani Manamela, a attorney and formerly an insolvency practitioner, but now obviously, or not obviously, only participating as an attorney in as far as liquidation insolvency matters are concerned. You will see also that I was involved or still involved to some extent with the law schools, so the lead schools, in as far as insolvency is concerned. And then there's an advanced insolvency training course also by lead that is coming up in August that I've been taking part in. My famous quotation there that is quite fitting for the times we're in is about greed, and in as far as insolvency is concerned, sometimes that attribute or trait plays a role. Maybe before we go on, I had, or in as far as I have my program, I will allow questions and answers right at the end. Actually be about 20 minutes, from 20 to 1 till about 1 o'clock, but I'm prepared to obviously stay longer after 1 for those that still have questions. But formally, we will break at 1 o'clock for the day. But if you have a burning question, been something that can't wait, or if it wait is going to affect your understanding of your participation, you're welcome to stop me right away and ask the question so that I don't leave you behind. But if you can wait till the end, I'll appreciate that. And then perhaps sometimes you find that you raise a question on a topic only to find that it also affects another topic. And then your question gets proven premature. So it helps sometimes to wait until all the work is presented and then it might give you a better idea than what you had at the time when you felt you had a burning person, when it's not. But as I said, you're welcome to stop me at any time. The aspects that we're going to cover are those appearing on your screen, starting with the personal sequestrations by way of voluntary surrender and compulsory sequestration. And then later, after the tea break, we're going to deal with liquidations, followed by business rescue towards the end and compromise. But there will be an interlink between the various topics, as the aspects ordinarily they don't present themselves singularly. They may come to you as a lawyer or insolvency practitioner, interlinked and being more than liquidation or more than sequestration. It happens especially when a company goes into liquidation that there will be aspects relating to surety, the liability of the directors and all those things. And then subsequently, you get involved into sequestrations and disposition that may need to be set aside. So it's not topics that are in silos, they are interlinked. The legislation that governs insolvencies and liquidations is a little bit, I would say, all over. There was an attempt way back, I think it's more than 15 years now, by the University of Pretoria, Professor Borain and them jointly with the Department of Justice to unify the pieces of legislation and come up with a Unified Insolvency Act. A bill was produced, and I think it's somewhere in the minister's table. Then it was Minister Penuel Maduna, and there obviously has been other, or have been other ministers thereafter. But maybe it will gain traction soon, and we will one day have a Unified Insolvency Act. As you know, the 2008 Companies Act does not provide for insolvent companies, winding up or liquidation of insolvent companies. We're still using Chapter 14 of the 1973 Act, which is left, I would say, hanging through Item 9 of Schedule 5 in the New Companies Act. I'll be using words like new and old, but something that is, it was the 2008 was effective 2011. So it's new by way of comparison with the 1973 Act, which was repealed, barring for Chapter 14, dealing with liquidation of companies, which is what we're going to be concerning ourselves largely. I was saying maybe that should be an indication that there will one day be a Unified Insolvency Act, because the New Companies Act has left it out, and maybe one day we will have such an act. For solvent companies, the 2008 Act do make provision, is in Part G thereof. I will refer you to some recent cases where this came up, where there was confusion and all that. But when dealing with voluntary surrender or compulsory sequestration, by way of legislation, which is obviously not the only law, you will know that. But legislation, it will be the Insolvency Act 24 of 1936. And then that is when you're dealing with sequestration of estates, insolvent estates of natural persons and partnerships, or the compulsory sequestration thereof. When you're dealing with liquidation of companies, you will use Chapter 14 of the 1973 Companies Act. when you're dealing with solvent companies, and you probably will be asking yourself, why will I be liquidating or winding up a solvent company? It does happen. The common ground is the just and equitable ground, where there is deadlock amongst, especially in smaller companies where the directors and shareholders are the same people. When they deadlock in terms of things relating to directorship, and there's no mechanism to break the deadlock, they also deadlocked in as far as shareholders meetings are concerned, and therefore you have got no way of going forward than to possibly wind down the business. There are other examples. The just and equitable ground is quite a broad ground that gives our courts a jurisdiction to wind up companies if equity and justice so dictate. Then you will have in the old companies, like Section 339, which says that you are allowed to use or to refer to the insolvency, the law of insolvency, where the Companies Act doesn't provide, but it will only be in respect of liquidation or insolvency issues relating to companies unable to pay their debts. So if you are liquidating or winding down a company on any other basis, like where, for example, let's say with the Football World Cup in 2010, there were companies formed there, and those companies were subsequently wound down or liquidated due to the fact that they had reached their purpose. Right after the last ball was kicked, there probably was other business to conclude. It took a few years, and I think I saw on the bond of security that about 3 companies were liquidated by way, I think it was by way of special resolution. Obviously, that won't be on the ground that those companies were unable to pay their debts, but on other grounds. But if you are to get the benefit of Section 339, wherein you can refer to, you're not only confined to the law primarily focused on companies, and you can use the law relating to insolvency, that is with regard to companies unable to pay their debts. A similar provision exists for closed corporations under Section 66, but that takes you to the Insolvency, the Old Companies Act, and also the Insolvency Act. So you get a benefit of the, if you're liquidating a closed corporation, and the matter is not specifically provided for in the Closed Corporations Act, then you can use the Old Companies Act. And obviously, by way of Section 339, you can then opt and be extended to the Insolvency Act. Then there is something that is a quasi-insolvency, is not necessarily insolvency law. Is Section 74, is quite unregulated. If you remember, part of the complaints, and I'm not saying that I'm really privy to all the relevant issues in this regard, but part of the complaints of the Marikana, before the Marikana tragedy, the mine workers were saying that they are subjected to administration orders which leave them with nothing at the end of the month, only few rents, and sometimes they find themselves facing more than one administration order with all money taken, and forever they are not without any income. They're without any income or meaningful income due to these administration orders. They do only provide for total debts of 50,000. So instead of invoking the voluntary surrender or compulsory sequestration method, this method is available. The debts, if they exceed 50,000 rand, obviously that will have to be a formal sequestration application. The last increase in this, I think, was in 2014 to the 50,000 range. Probably anytime soon it will increase. But I saw that there is the Law Commission under the stewardship of Professor Borain. I think there's re-looking at this provision. And perhaps it will be come up as something quite bigger or incorporated in our mainstream insolvency law. Then there is something that is quite like a new kid on the block, so to speak, that is business rescue, which is the flavor of the moment. You go to court with with a liquidation application for a company. You often will get defeated by an answering affidavit or defense saying, let's try business rescue. It is not there for the asking. It has got very specific requirements and is not there to be abused by anybody trying to fend off liquidation. But its provisions are in Chapter 6 of the 2008 Act. Then the National Credit Act also features in respect of natural persons. And also when it applies to companies, there is that limit. Can't remember the exact figure now, but I should be able to get it in a day. But we won't be dealing much with, if anything, with National Credit Act is a topic on its own. But often you find that persons, when they're facing insolvency circumstances, they do apply or seek the mechanisms in terms of the National Credit Act for relief. And that is quite available. As I've said at the beginning, our law is not in silos, it's quite interlinked. And the one area could be dealt with in as far as relief or defense is concerned by another area. So in short, those are the primary legislations. But obviously, when you're dealing with matters, or when you're seeking a remedy, you're not only going to rely on legislation, you will have the benefit of textbooks. I'm mentioning textbooks there for voluntary surrender, which is the topic that we're about to get on. Obviously, those textbooks are just by way of examples. They could be more, or they are definitely more. But those are the ones that you can use. And if you find anything more, you can. The uniform rules of court are quite advanced. For example, in as far as applying for voluntary surrender, the practice manual of the Pretoria High Court, and I think it also the Joburg High Court. I may not be aware of the other high courts elsewhere. The practice manual do provide for what is to be contained, what is to be established in applications of for voluntary surrender, in a way to try and prevent abuse or regulate the bringing of this application. Obviously, that is a practice manual is supposed to apply to procedural issues, but they do encroach on substantive issues. There was a complaint, I think, about a year or so ago from the Law Commission saying that judge presidents or the courts must know they're now encroaching and they must know their limits or boundaries in as far as practice directives are concerned. Because the confusion will be where you have a matter and the law says something, and then you get defeated or get a hurdle that is posed in terms of the practice manual. Then you have your case law, decided cases, which is mostly where the living law or the evolving law is created. And that is quite helpful, especially as you'll see when dealing with business rescue, which came through as a new concept on our shores, 1st of May 2011, and then we had to apply it, and we had only had what was called judicial management. But We're still under voluntary surrender. You'll see when we get there. So these are the primary references. The concept of voluntary surrender is something that often is not utilized, but sometimes is quite abused or even misunderstood. As the name itself says, it is a voluntary surrender, which means a natural person or persons who are sharing a joint estate, either they're married in community or property, or they can maybe same-sex partners, or they may be married traditionally. As long as they have what is called a joint estate, they may apply jointly under this concept of voluntary surrender. So they may voluntarily surrender their estate into the hands of the master, and thereafter the trustee that is to be appointed. So the person who's invoking this method, when I say person here, you must also include partnerships. I'll explain towards the end as to how it works in as far as partnerships are concerned. Let's stick to natural persons. The person or persons married in community property or sharing a joint estate will have to be the applicant. They'll have to firstly determine what High Court has jurisdiction over their over themselves. That is where they're residing or domiciled. Maybe before I go on, can I just get a sense here? Are there any persons who are involved in insolvency on a daily basis, practicing in insolvency? Because I might be pitching this thing a little bit lower and find that somebody's going to sleep wherever you are. Is there anybody who's an insolvency practitioner or an attorney who specializes in insolvency law? Can I just see a hand somewhere? Yes, Nick. How deep are you, Nick? If you can switch on your mic. Or you can send me a message. I'm trying to give Nick a voice here, but I can't. Okay, I see Nick and I see a few others. Okay, then on the other side of the extreme, if I can call it that, are there any persons who have never done anything in insolvency law? Okay. 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 Yeah. Okay. Nick and others, please, you'll have to bear with me. I have to present this at the level where everybody will follow. There will be everything for everyone who's here. For people like Nick, it may be obvious stuff, and but here and there will be lots of things that come up that will interest you. Okay, thanks a lot. That really helps. Voluntary surrender works like this. You have what is called the requirements, and then you have what is called formalities. All these things, obviously, when a matter, whether you're an attorney or an insolvency practitioner, but probably let's just stick to those that wants to draft this kind of papers or wants to involve themselves in the litigation part of this. Obviously, when a client walks through the door, you'll rarely find a client who's quite sophisticated who will say to you, Mr. Manamela, I've got this thing figured out. I've already know I am actually insolvent. I already gone through the necessary tests and requirements in the Insolvency Act, and I know I've got even a draft for you here if you can settle or even sign and bring it in the particular High Court. No, it's not going to come as that. It's going to come probably as a client comes through to you holding a box of summons or just saying, hey, I'm in trouble. Can you negotiate with, I've got a letter of demand here. I've got a summons that I received last week. Can you assist me here? And obviously, what has to come into your mind is the various options. And when you come to voluntary surrender, you will obviously have to know that this procedure is not there to assist debtors who are harassed by creditors and simply wants to get rid of their creditors. What you will have to consider is, I call it a desktop test, is to look at the requirements before you even draft the actual papers. The requirements are there in the Insolvency Act, as already mentioned. So what you will have to look at is actual insolvency. Are how are the assets of this particular estate faring when they're compared to liabilities? Okay, firstly, you'll have to determine the marital status of the particular person who's before you. I'll tell you about a matter in about 2 years ago where a husband was, the estate was sequestrated without the involvement of the wife, and it created sort of complications. So you determine the marital status and you know whether this person is married in commuter property or out of commuter property. And you must also be modernized in your thinking. By that, I mean the following. Is no longer your traditional marriage of the one that is reflected on documents and at Home Affairs. There could be traditional marriages, which are assumed or presumed, I think is the law, to be in commuter property. So when a person, I think ordinarily to be a black person, walking through the door and saying, hey, I'm not married, you may have to dig a bit deeper to find whether this person is not married by way of traditional law, customary law, as it's called. Or it could be a person who's married in terms of the Civil Union Act, which applies to same-sex marriages. And it could be a marriage. I don't think the Muslim or Islamic marriages bill has already been passed. But you need to be aware. You need to dig a bit deeper and be aware and ask for proof where it's required. Then you have to find the court where these people are domiciled, residing. Or if that person has got a business that they're conducting in their own name, that business will also form part of the estate. Then it may be that you follow the jurisdiction of that particular business if it's the source of most of the creditors. So it's a practical thing. But ordinarily, it should be where your client, the applicant or applicants are residing. Then once that is sorted out, you will know, you will have to find the practice manual or practice directives of that court to know what do they say about this kind of application being a voluntary surrender. Then once you've done that, or you can do it at a later stage, the practice manual thing, then you'll have to consider whether the requirements for voluntary surrender have been met in as far as our law is concerned. First, you have to look at, is there actual insolvency? That is done by way of comparing liabilities with assets. Okay, I'm going to jump to slide 9. There I've got a typical estate with what I could call also typical liabilities. In this hypothetical person's estate, you have assets on the one side, that is the left-hand side, and liabilities on the right-hand side. Somewhere the liabilities do have some encumbrances or security over them, but we'll deal with that when we deal with the next requirement. For now, we have to determine whether there is actual insolvency, which is a determination that assets of this hypothetical estate, when fairly valued, are exceeded by the liabilities when fairly estimated. Don't be worried about the fair value, fair whatever. It's not there. It's not as precisely a requirement in the Act, but it's a requirement that came from our case law to say the assets have to be valued. For example, the practice manual requires that when you referring to assets as involuntary surrender, you present a valuation, some valuation. Then the liabilities fairly estimated. You may not be aware of to the liabilities, your liability to send. For example, you might be receiving monthly statements from banks, which doesn't really show all the interest that may have accrued. So its liability is fairly estimated. But when the two are compared and the assets are exceeded by liabilities, as in this example, right at the bottom, by 100,000, then you have actual insolvency, which is a requirement that must be met for a successful voluntary surrender application. So then I'm going to go back to the previous slide, slide 8. So now we know that actual insolvency is there because in this hypothetical estate of Mr. Manamela, who's unmarried, the assets are exceeded by liabilities by 100,000 rand. Then we go to the next requirement. There must be sufficient free residue to defray cost of sequestration or to pay for cost of sequestration. Okay, what does this mean? Let's go a little bit forward to slide 10. Free residue simply means those assets in the estate that are not subject of any security. Let me just try and get that. We go back to slide 8 to determine what is the meaning of security. Section 2 of the Insolvency Act defines that. It says, in relation to the claim of a creditor of an insolvent estate, security means property of that estate over which the creditor has a preference right by virtue of any special mortgage, landlord's legal hypothec, pledge, or right of retention. So if, for example, a creditor says, I've got security over an asset of an estate, and it doesn't fall in any of these categories, then it doesn't constitute security in terms of our Insolvency Act, and therefore it's not recognized. Your typical example will be your surety ship is not recognized as security in terms of the Insolvency Act. The special mortgage includes both movable and immovables. In movables is normally called notarial bond, but only a special notarial bond will constitute security as special mortgage. That's why you will have heard of something called perfection of security. That is where a creditor who had only a general notarial bond over the assets of an estate will try and get an order where he specifies the assets to turn it into a special notarial bond. But then over immovables, you have a mortgage bond. That is the normal bond over a house. Then landlord's legal hypothec will be normally with regard to a debtor that is occupying leased premises. The landlord there will have a legal hypothec over the assets, their limitations and their requirements as to the establishment of this security. Then there's a pledge where you pledge your shares, some documents. It's not quite common, or share documents. Right of retention is the one that is normally called retention of ownership, which applies to things like your cars and the like. Okay, then now that we know what security is, we can be able to identify it on this slide 9 with the assets. For example, let's have a look at the table. You have assets, which is an immovable property. It's called F130 Gordon Road. Obviously, when you draft your papers, you must make sure that the description of the immovable property is exactly as it is in the records of the Register of Deeds, in the Deeds Office. So you will need to have access to, for example, the Deeds Office or one of this software that is normally used. Experian, that's one that comes to mind. There are others that you can press a button and you get the assets listed under your client's name. So, but the description must fit so that it's exactly what it is. Then over this particular immovable asset, there is a security, which is a special mortgage in favor of Nedbank in the amount of 1.2. And then the fair valuation of the assets is at 1.3. Then immediately you see there that there is an amount of 100,000 that is not subject of security, but the immovable asset, that is this ERF, is encumbered, and therefore it does not form part of a free residue, but only in an amount of 100,000. So we have 100,000 there from that asset. Then we go to the next asset, because you can only look at the asset and then you look at the liability. Here we have this fancy motor vehicle, is valued at 500,000 rands. But is owing the bank 1.1 million. As with cars, they deteriorate in value, and therefore, over this asset, the car, we don't have any free residue. Then we go to the next one, which is household furniture, valued at 500,000. Because this person is occupying his own house, there is no implication of the landlord's legal hypothec. It could be that if the person was trading, for example, in his own name without not having formed any corporate entity, hiring premises to do the trading, so there could be implications of the landlord's legal hypothec. But here, there is none. So the whole of the 500,000 forms part of free residue. Then we know at the back of our mind, we have 100,000 coming from the immovable property. So we already have 600,000 as free residue. Then we have investments over which there is no security. So we have 700,000 rand. And then we have, okay, at the bottom, I need to move to the next slide, sorry. Yes, the 700,000 rand that I've mentioned is there as free residue. And then to look at the requirement, because what are we busy with? We are busy with the requirement whether this estate will have sufficient money to pay for cost of sequestration, or cost of administration as sometimes called. So we cannot use money that belongs to that is going to come out of assets or properties that belong to creditors, secured creditors. So we are only allowed to use property or assets or part of the assets that is unencumbered. So our calculation has revealed that we have 700,000. And then to answer the question whether it will be sufficient, the 700,000, whether it will be sufficient to pay for cost of sequestration, I've assumed an amount of 100,000. What is cost of sequestration? It will be, firstly, the attorney's fees. If the attorney have used an advocate, the advocate's fees. The sheriff will have been involved. Probably the auctioneer will have been involved in turning the assets into money. There could have been storage fees. There could have been all sorts of things that will have been needed to liquefy my word. It's not there in any way in the act. Liquefy the assets into money. And then, yes, now we know the second requirement being that there must be sufficient free residue to pay for costs of sequestration has been met, because there will be 700,000 to pay for cost of sequestration of 600,000, and therefore that is sufficient. So we go back to our requirements. We have met requirement number 2. Then there's a requirement number 3, which is what I mentioned at the beginning, that the whole process is not just there to relieve harassed creditors. There must be an advantage to creditors. And the requirement of advantage to creditors is the following, that sequestration will be to the advantage of creditors. How do you reflect that? There must be a dividend that is not negligible. You are routing costs in terms of the practice manual require that there must be at least, I think it's 21 cents in the rand, or 20 cents in the rand. If that is there, it means that there is sufficient, there will be, advantage to creditors, the third requirement. Let's go back to our hypothetical estate and look at whether we have that. Okay, we have 600,000 on slide 10, and then we have to pay, we have to pay the creditors that we have to pay, and we have to determine how much they were going to get each. So to do that, you'll have to determine the identity of your creditors. So you go back to that table showing liabilities. You determine which creditors will be sharing in the money that is available. Okay, by that you're going to, by now, you already know that you have excluded the secured creditors. How did you exclude them? When you calculated the money that is going to be there to pay for cost of sequestration, the free residue, we didn't count the secured creditors. For example, with regard to net bank over the asset, the immovable property, we excluded the 1.2 million on that from that property, because it's going to go to net bank as a secured creditor. We only accounted for 100,000. Then for the car, which it owes more than its value, all the money over this asset is going to go to Absa Bank. So which means Absa Bank as a secured creditor is going to have to make up its mind whether it's going to claim only the 500,000, which is what is called relying on your security, or is going to look into the concurrent kitty. The concurrent kitty will be the non-secured kitty, okay? Kitty by kitty, I mean the assets, the money that is there, the 600,000 that is there after we've paid cost of sequestration, which is not subject of any security. So Absa Bank will have to make up its mind whether for the 600,000 that is a surplus or deficit from its security, whether it's going to claim as a concurrent creditor or not. And then we have another, okay, net bank is fully at the top of the table on slide 9, is fully secured, so it doesn't have any need to rely or not rely on its security. Absa Bank, as I've mentioned, is got to make up its mind whether it's going to be a concurrent creditor or non-secured creditor for 600,000. Then you have further down employees' salaries, which are preferent claims. Employees are, by way of our law, Insolvency Act, preferent creditors. They rank on top of SARS, which is another preferent creditor. Initially, I think about till 2003, if I'm not mistaken, it used to be the other way around, where SARS will come on top, take all the money, and then there won't be anything for employees and everybody. So that was changed. The sequence was changed subsequently. But there is obviously a determination, a cap as to how much of the employee salaries could be considered preferent. We'll deal with that in a moment. Then you have miscellaneous creditors. So in this column, you have both your preferent creditors and ordinary concurrent creditors. I don't want to confuse you. Probably at varsity, you may have been told there are three types of creditors: secured, preferent, and concurrent. They're actually secured and unsecured, which is otherwise called concurrent. But at the top of the concurrent pile, you have what the law has designated preferent claims, and therefore you'll have the preferent creditors. But it doesn't really make any difference. So how are this going to help us determine how much creditors are going to get? You go back to, you take the 600,000 on slide, which was left after we paid for cost of sequestration. Take it to slide 11. And then you say, okay, I have to pay my preferent creditors first. And we're assuming that the total 150 that is owed to SARS and the employees is preferent. That is not, the employee salaries are not over the cap or the limit. So when you take that, you minus it from the 600,000, you'll be left with about was 450. But then you have Net Bank that is been owed 1.2 million, and Absa Bank that is owed, I think I didn't reflect the Absa Bank thing, but you have those secured creditors that couldn't really satisfy their claims from their own property, their own claims over which, or asset over which they held their secured claims. Those we have excluded. We have assumed for purposes of this exercise that they rely on their security and therefore will not bother the concurrent creditors. So the 600,000 will only pay the preferent creditors, and then the remainder 450,000 will have to be divided by 650, which is the remainder of the concurrent creditors. Where did I get the 650? Let's go back quickly. The 650 will be you have the I took out some of the things here. Yeah, the 650 will be, I think I might have mentioned something out of 10. You have the 500,000. I think when I revise this notes, I basically change some of the figures. Yeah, okay. You'll have to forgive me for that. Let's assume we have the 450 and then you have the 650. I'll in a moment try and find where the 650 is supposed to represent the concurrent creditors that are not preferent creditors, that are also not secured claims. So this will be non-secured, non-preferent, concurrent claims. So you take the amount that you have, you divide it by the amount of the creditors that you have to pay. And in this example of mine, which appears to be in a way failing me, but I'll fix it up in a moment, we have 69 cents in the rand, which means then now answering the third requirement, will there be any advantage to creditors, or are we just here to relieve this harassed debtor from its or his creditors? Yes, there will be advantage to creditors because every creditor will get about 69% of their claim paid, which is otherwise been said as 69 cents in the rand. For every cent that they've been owed, they will get 69 cents, which is a good dividend. You won't find it in most of the applications that serve before our courts. And as I've said, the practice manual only requires about 21 cents or 20 cents in the rand up here in Gauteng. So going back, you will say you've already met the three requirements. There will be sufficient free residue to defray the cost of sequestration. Just a moment for me. So with that, I can safely say that the three requirements for voluntary surrender have been met. And then now you can get into the formalities. The formalities are with regard to the notice requirements. Because obviously this is an application where the very same data, I can call the data the culprit or culprits if it's more than one data. Other ones bring in the application. So therefore, if there are no controls, they can bring it in such a way that it's disadvantages, or it doesn't even reach the news, don't even reach the affected persons, which are creditors. So the law has placed some requirements in place to ensure that notice should get to whoever it needs to get to by publication of what is called a notice of surrender in the government gazette and local newspapers where the applicant or applicants are residing. So how does the notice of surrender? I've got an example. It looks like this on slide 13. You have a form that is a prescribed form that you'll have to complete. When you complete it, is basically going to look like this, but once it's completed, it will look like this. When it's published in the government gazette, it will be like this, reflecting all the necessary requirements. I put my name there and I've embellished my ID number to make me seem older and mature and all that. But this is what will appear in the notice of surrender. It will show the court where the matter will be appearing. Okay, firstly, it will show the name of the person, the ID number, the trade or occupation, the marital status, address of residence, the place, the court where the application is going to be brought, the date at which the application is to be brought, the time on that date that the application is going to be brought. And then finally, it will state when something called a statement of affairs is going to lie for inspection and where it is going to lie for inspection. And then right at the end, it will give the contact numbers of the person who's publishing in case there's an inquiry. Okay, you publish the notice of surrender not more than 30 days and not less than 14 days of the date of the application or hearing of the application. It sounds very complicated, but it's not. All that it is that you must firstly establish the date on which you're going to bring the application, on which the application is going to be had, which requires contact with your registrar of the High Court, because it's only in the High Court that you can bring a voluntary surrender application. And then once you're given that date, it must be the date that will allow you to publish the notice of surrender. Let's assume that the date for all intents and purposes is let's just try and get a date on which today is the 27th of May. Let's assume that we're going to bring this application for voluntary surrender. The day that has been given to us is the 30th of June 2022. So what it means is that our notice of surrender must appear in the government gazette and the local newspapers not more than 30 days before this date. Not more than 30 days means we cannot publish this notice of surrender prior to the 1st of, we can say the 31st of May 2022, because it's first day in, last day, first day out, last day in. and then the not less than 14 days means that we cannot publish it later than the 16th of June 2022, which means our government gazette publication and the newspaper publication must appear between the 31st of May and the 16th of June 2022. But then there's another practical issue, which is the government gazette doesn't come out every day. It comes out on Fridays. And also the legal classifiers can also come out on a Friday. So in that example, again, when you look at the calendar, I could see that we have the Friday of the 3rd of June and the Friday of the 10th of June. So we've got only 2 Fridays on which the notice of surrender is going to appear. So those are the practical things you have to consider. So once the notice appears, then you got to within 7 days. Let me go where the rest of my requirements. Yes, I'm on slide 15. Yes, Barbara, I'll use the branded slides. I think I made a mistake when I uploaded here that I used some other slide. I'll take this down and put the ones that I should be using. My apologies. Not everybody, the law knows that not everybody reads the government gazette and the local newspaper. Therefore, there's got to be a specific notice sent to every creditor by registered post. So you're sending the very same notice of surrender to the creditors by registered post within 7 days of the publication of the same notice in the government gazette and the local newspaper. Years ago, I've had a bit of a predicament where I mix up my date. I forgot to publish in the local newspapers. I saw it only on the Friday, and I remembered, oh yes, it must be. I should have advertised the local newspapers, and I didn't. The law doesn't say it's got to be on the same day, the application, but obviously the healthier is on the same day, because how else do you calculate your 7 days? So I had to publish on the Monday, 3 days later. And then when you do that, it's no longer a classified ad, it's an advertisement. You pay probably about 200 times more. I didn't make any money out of that estate because all the money went to paying the Star and the other newspaper. So you need to synchronize or keep your diary well to make sure that you don't fall into my sort of a situation. So within 7 days of publication, so assuming that you've published in the government gazette and local newspaper on the 10th of June, then it's the government gazette, the notice of surrender to every creditor has to be by the 17th of June. Remember, these are ordinary days, they're not court days. So it's calendar days. Then after that, on top of notifying the creditors, you have to notify the registered trade union if this natural person or partnerships have got the employees, or you got to definitely in your founding papers, you got to specify that there are no employees and that there is no trade union, or there are employees, but there is no trade union, that you're going to affix a notice in terms of section 4.2 B Roman figure 2AA of the Insolvency Act at a place of the employment of these people. So as a house, it will mean that you put it somewhere where the people who are working in the house or the garden or somewhere should be able to see it. But it's a notice requirement that you must also, other than notifying the creditor, it must be the registered trade union, it must be the employees, or sometimes it should be registered trade union and the employees, or if there is no registered trade union, just the employees, as well as South African Revenue Service. These requirements were not there prior to, I think they came up in 2000, 2003, somewhere there. I'm running out of time. I was going to tell you a story where I went and the employees didn't know about it was in liquidation of a company. And maybe let me talk about that when I reach liquidation of companies. Then with that, we are halfway through the notice requirements, but then there's something that I've already mentioned when I dealt with the contents of this notice of surrender. Is something called statement of affairs, which is a prescribed form as with the notice of surrender. The form itself is what I use when I consult it with my client right from the very beginning. What it requires, the full names, it requires all sorts of affairs or information about your client. So if you complete that, you will have a very good idea as to what the assets and liabilities and personal details of your clients are. But here, for voluntary surrender, it is required as a formality to be met for a successful application. You complete it, it will require the full names, marital status, place of residence, assets, liabilities, claims in favor of the estates and all that, and it's got to be done. The information has to be furnished under oath. So if your client somehow embellishes or under declares on this statement of affairs, there could be implications of perjury. So one has to be careful as to what how this thing is completed, but it's got to be completed and lodged. It must be lodged with the relevant places. The law is a bit complicated, but not that much. If your client is residing within the magisterial district, that is at the same as the master, that falls in the same district as the master of the High Court, meaning your client and the master fall within the same magisterial district, then you only have to advertise at the master of the High Court. But where is got to be where it's outside of the jurisdiction, then you got to make sure that it lies, the statement of affairs lies for inspection at the master of the High Court and the magisterial district. Sorry, I swapped it the other way around. It's supposed to be the magisterial district, and then if there are, you have to do both the master of the High Court and the magistrate court. So if you are in doubt, you can always ask the master of the High Court and you give them a magisterial district, because sometimes determining in some borders, especially outside of the big cities, as to what magisterial district is there, although they get published, but the Gazette they take, there are some towns that are border towns that in one Gazette it will fall within this district or even province, and at the next it will fall somewhere else. But the statement of affairs must lie for inspection for 14 ordinary days. It counts even the weekends prior to the hearing of the application. So by the time the application is heard, it must have lain for inspection for 14 ordinary days. Then you must, a practical issue is that you must factor in that you must be able to get a certificate back from the magistrate court, from the master of the High Court, it is both, which you'll need to present to the court, hand it up when the matter is heard, to prove that you've complied with this formality. So with that, you have met all the formalities. And then when we go back, I'm rushing quickly back to the beginning of voluntary surrender, slide 8. Once you've met the formalities and met the actual insolvency requirement, sufficient free residue requirement, you have shown that there will be 69 cents in the rents and therefore advantage to creditors. And then you have the ingredients of or contents of what suffices for a successful voluntary surrender application. And the other practical issues are what has to go in, or it implicates, it comes in basically after the application has been granted. But what I've already mentioned is what you will require. Besides compliance with the practice manual applicable to your town or area of practice, to bring the application. For example, the practice manual here say that you must be a form that you appears on the outside of the application, showing compliance with all sorts of these requirements and formalities, as a sort of a checklist for the judge and everybody that you've complied. The consequences of publishing a notice of surrender, because when you publish a notice of surrender, what it means is that the creditors are not allowed to sell without the consent of the court the asset that may have been attached belonging to the estate of the person who's publishing the notice of surrender. But because that could be abused, somebody could just put the published notice of surrender and say, I'm going to bring such an application next year, November the 1st, and therefore you can't touch my estate in the meantime. Then to prevent such abuse, basically there's that limitation that you can't publish not more than 30 days, not less than 14 days. But also that if you publish and you don't follow through, then that amounts to an act of insolvency, which is something that we'll deal with next under compulsory sequestration. But the consequence of publishing notice of surrender is that the estate cannot, assets in that estate may not be sold in execution unless the court has authorized same. Then if the application, the notice of surrender is published, and then 14 days after the date that has been indicated will be date of application passes, and there is no such an application, then it will lapse and you won't have an effect of protecting such a debtor. But obviously it will have the effect of constituting an act of insolvency, which could entitle a creditor from bringing compulsory sequestration. With that, okay, I just have to wrap up on voluntary surrender of partnerships. Everything else is the same as in natural persons, but the only difference is that where an estate of a partnership has been surrendered, voluntarily surrendered, all or each and every partner's estate, they must be simultaneously surrendered. But the converse doesn't apply. Where a natural person or a partner in a partnership surrenders his or her estate, it doesn't oblige or compel the other partners to surrender their estate, nor does it oblige or compel the partnership to surrender its estate. But where the partnership collapses, the partners will have to go with it. It makes sense because partnership doesn't offer the benefits of juristic personality, and therefore that its assets and the partners are liable for the asset liabilities of the partnership, except for the partners at commandite or anonymous. Those are not affected. The notice requirement basically that it must be published. There must be notice of surrender. There must be a statement of affairs, just the same as it is for natural persons. But obviously, where you're dealing with a partnership and simultaneously each and every partner's estate, there's going to be an involved process which will require more than one estate. One thing that I need to mention is that you don't sequestrate an individual, you sequestrate the estate of that individual, and the individual gets declared insolvent. So when we say in everyday terms, so-and-so has been sequestrated, it is incorrect. What has been sequestrated is their estate, and they've been, as a result, declared insolvent. Let me quickly, I'll take a break. I plan to take a break exactly now. I'll extend it till about 11:30. I just want to wrap up with natural persons sequestration by dealing with compulsory sequestration. Okay, slide 19, I already touched on it before at the beginning. Compulsory sequestration is obviously the opposite of the voluntary surrender. Here, the creditor is the one taking the initiative to bring the application. And I'm saying your source is almost exactly the same as voluntary surrender. And there is more. These are only examples. How do you go about this? It doesn't have the formalities, the same formalities as voluntary surrender. Hence, people will run away from voluntary surrender and try to simulate compulsory sequestration. And then we end up having what is called friendly sequestrations, which we will conclude under this topic. Compulsory sequestration can be brought, and again, is only the High Court, because it's a status application, as with the voluntary surrender. The High Court with jurisdiction, who can bring this application? It can be a creditor or creditors, jointly owed, at least 200 Rand. If it's a single creditor, that creditor must be owed at least 100 Rand liquidated claim. I will in a moment refer to the matter of VBS and Mazonga, the issue which was occupied our court quite recently, the whole issue concept of liquidated claim and as to how much is to be shown. A debtor, a creditor rather, having a liquidated claim of at least 100 Rand, I'm yet to see such a creditor featuring, but it's at least 100 Rand, which means that even as in the matter of Mazonga, where Mazonga said, no, I've got lots of assets. Yeah, is the let me just get. I'll send you the citation thereafter. But it's a Mazonga. It's a Houghton matter, decided in August 2019. Mazonga said to the court, "No, I have more than 100 Rand, or I have more than what is claimed." But then there were concessions which convinced the court that 100 Rand at least has been proven. The court basically has said it doesn't matter whether you have some reasons why you are not paying the bigger amount. But then basically, if an 100 Rand can be shown, that suffices. And therefore, there is no need to establish the whole amount. So if 100 Rand liquidated claim is being shown, then there could be a successful compulsory sequestration application. If such a claim is secured, does it preclude the person from bringing an application? No, but my question will be why bring an application if you could use the selfish method of debt collection where you issue summons and use your security to recover the particular debt? But sometimes it could be where you're thinking the subject of my security, the asset, may not be able to yield what I require, and perhaps there's a need to trigger the machinery of insolvency for the benefit of a general body of creditors. But security is not a bar. Requirements, you'll remember in a voluntary surrender, we had the 3 requirements. Here you have actual insolvency, which is sometimes referred to as factual insolvency, but is basically the same as in voluntary surrender. Liabilities, when fairly estimated, are exceeded by assets when fairly valued. So when you have that, you have met the first requirement for compulsory sequestration. But then there is more, because obviously creditors don't sit at arm's length. Sorry, let me just rephrase that. Creditors are not privy to what is going on, the assets and liabilities of their particular debtors. They're not required to. So therefore, other than actual insolvency, there is what is called acts of insolvency, which are listed under Section 8 of the Insolvency Act. It is coincidentally 8 of them under Section 8. They include your nulla bona return, which is where the sheriff goes and not sufficient assets are shown to satisfy the judgment. Absenting a debtor absenting himself or herself from a place of residence or place of business. A debtor trying to enter into some arrangement with his creditors. A debtor preferring creditors, one creditor above the other. Those are acts of insolvency or colluding with some of the creditors. Once that is present, that suffices to be an act of insolvency. And together with the next requirement, which is that there is reason to believe that sequestration will be to the advantage of creditors. If you remember, when we dealt with voluntary surrender, we had almost a similar requirement, which is what I'm saying in the next line, is there it was a definite under voluntary surrender because the person making the averment is the applicants themselves. They have to say sequestration will be to the advantage of creditors, as opposed to a creditor who's owed at least 100 Rand liquidated claim, who's sitting far away from, is not privy to what is going on, doesn't know whether assets are exceeded by liabilities, doesn't know what whether there will be a dividend, and if it will be, how much of that dividend will be. So it's not required to say definitely there will be advantage creditors, but you say there's a reason to believe on the basis of the facts that I have that sequestration will be to the advantage of creditors. Often what is being said in papers, court papers, is that this particular debtor owes me money and it seems to be overstretched. And then you bring factual, it could be aware of another creditor. Sooner or later, this debtor is going to dissipate the assets to the disadvantage of creditors. It's better if the machinery of insolvency is invoked. A trustee is appointed who will take care of the assets of the, will gather the assets of the estate, sell them, and then distribute the proceeds thereof in terms of the law to the benefit or advantage of creditors. If you show that, obviously, or make those amendments, then the court will consider this requirement met. So then you will have the requirement of actual insolvency or an act of insolvency and advantage to creditors. The third one of free residue that we had in voluntary surrender, no, it's not a requirement because this is an application that is potentially being opposed. And then you'll see how the respondent has been protected. You will need as a formality to furnish security to the master. Security for costs. That is, the creditor will need to furnish security for cost because this application could basically be ill-advised, and if it's not successful, the debtor will have the benefit of to cash in with the security for cost. Often, the security for cost is a document that we as lawyers will complete without even thinking twice, and we are basically undertaking that, or on behalf of our clients as creditors, that we are good for the money. Obviously, you pop into the master, you complete the forms, and then they stamp them for you to attach to your application. And that the requirement is met. Obviously, what is required is that at the time when you bring in the application, there must be proof of having furnished security for cost in the form of a certificate. Then you also have the notice requirements. Notice requirements will be the same as with voluntary surrender. Obviously, you'll have to notify the respondent, which is the debtor, unless there is agency. But obviously, you'll have to mention if it's such agency where you cannot notify the respondent. Sometimes where you suspect that the respondent will start hiding assets, and then you say, no, I don't want to notify the respondent, but the court is going to be hard pressed to inquire as to whether justice will be served by an application that comes through without notice to the respondent. But the other statutory interested parties, being the employees, trade unions, and SARS, they have to be notified. Often, if this is not met, it can be used as a ground to rescind a judgment later on. When some interested party says, no, I'm an employee, or I'm a trade union, we're not notified. But these are the notice requirements. There is no notice of surrender. It's the normal service of the actual application on these entities. There is no need for a statement of affairs to be lodged. It's not there. It's not a requirement. In some courts, they will require that you must serve a notice with a copy with the master. But you can simply say in your application that you will give a notice to the master and then have a stamp to prove that by the time the application is had. That one is normally you'll find you must give at least 5 days. I've seen applications where 2 days are given to the master. Is not compliant. It may not be a ground for refusing the application, but it's short notice, which could affect the other issues or the outcome of the application, or even a postponement to see if the master has anything to say. But the master will have possibly not much to say because it's still a fresh application. So these are the formalities added to the 2 requirements that we've seen. And once you have that, then you're ready to bring an application. The rest, the contents of the application is basically like a love letter. You can start them the way you want it, or the love letter will apply to people who are slightly older, pre-WhatsApp times when there has to be a love letter on a writing pad. How you begin it and how you end it is not prescribed, but as long as it's got all the relevant contents. So that is exactly the contents of the affidavit. As long as you establish, obviously, the court has jurisdiction, the person bringing the application is owed at least 100 Rand liquidated claim or debt. The respondent is residing or trading within the area of jurisdiction of the particular court. And then the requirements, yes, there is actual insolvency or an act of insolvency has been committed. On top of that, there's reason to believe that sequestration will be to the advantage of creditors. Remember, you cannot just make bare affirmance. You will need, like, for example, because you are allowed to show, if you are aware of the assets versus liability situation of a particular debtor, you are allowed to show that there is actual insolvency. But if you are not aware, you can only simply rely on act of insolvency. You can rely on both. They're not mutually exclusive. The court will not punish you for that. Okay, I mentioned at the beginning that there is a tendency to run away from voluntary surrender and simulate a compulsory sequestration when is in actual fact is not. For example, a father will say, oh, I borrowed some money, loaned money to my daughter, my lovely daughter. I hate her so much that after she failed to pay me, she sent me a letter which father and daughter communicate by way of formal letters. But you'll see a formal letter sent by the debtor daughter saying, I can't pay you, can I pay in installments, and thereby committing an act of insolvency. And then the father using that to bring a compulsory sequestration, in inverted commas, application before the court and saying, I'm liquidating I'm sequestrating the estate of this particular debtor who's my daughter. The courts will, they can't prevent that. But they will require that the claim itself be vouched. For example, where a father says, I lent an advance 10,000 rent, there must be proof of the 10,000 rand leaving the account of the father or reaching the account of, there must be proof of that money having exchanged hands. Obviously, people can still simulate those transactions, but the court tries harder to prevent abuse or collusion, but obviously it's not error proof. There could be those that go through. So those are your friendly sequestrations, which are compulsory sequestrations that are brought by people who are friendly to each other. The whole idea is that often not you find that creditors are suffering because there's no, for example, there's no statement of affairs where the assets and liabilities have been placed at a public place for inspection, as with voluntary surrender. There's under declaration of assets as a result, and therefore creditors disadvantaged. But further than that, there's nothing. This will basically become compulsory sequestration. Sequestration of a joint estate is exactly what is like in a voluntary surrender. You have to, if it's husband and wife, or people married as same-sex union, or customary marriages, you have to apply or cite as respondents all those persons. Partnership, I've already mentioned that when a partnership is being voluntarily surrendered, each and every partner had to surrender their estate. That is under voluntary surrender. Under compulsory sequestration is the same thing, where the estate of a partner, of a partnership is being sequestrated. Each and every partner's estate will have to also be simultaneously be sequestrated. But where you are sequestrating an individual partner for something that has got nothing to do with the partnership, where you won't be bringing an application for the compulsory sequestration of the partnership, then you don't have to cite the other partners' estates, or sequestrate the other partners' estates, or even that of the partnership. Then moving on, intervention by a third party is possible. Yes, banks normally come through and say, oh, the whole thing is an abuse. There is no asset in this estate except for that house over which we have security. We've been trying to sell that house for years, and the value that has been put in the papers to show that there will be there's reason to believe that sequestration will be to the advantage of creditors is a farce, because we've been trying to sell it for so much rents, and we've been failing. There is no interest in the market. We're going to, even if we sell at the end, is going to fetch for less. So therefore, we don't want our asset being diminished by this collective method of debt collection, which is insolvency. We want to stop. The application must be dismissed so that we can sell it on our own separately. Can you do urgent applications? Unlike in voluntary surrender, yes, you can in compulsory sequestration. Obviously, you've got to meet the requirements of Rule 6 of the Uniform Rules, as well as the contents of the practice manual. Okay, with that, let's take a break. I'm running slightly behind schedule. Let's take a 10 minutes break and be back at 11:44 to proceed with what we're doing. I'm going to remove this presentation to present the one that has got a branding from lead. Thank you. Okay, we're back. Can you check whether you have your hand up and whether I see Justice Mulai's hand is up and Bradley Claviani's hand is up. When I was busy, I didn't really see that you had your hand up. Okay. Justice still has his hand up. Is there anything there that I could help you with, Mr. Mulai? Okay. I'll assume that he's got nothing, and let me maybe lower the hand and. Okay, let's proceed. I hope the correct slides are up now. We were about to start with rehabilitation. We're going slightly behind schedule, but we should be able to recover. I'm the one who put you there. I should be able to get you out of it. When you are Hollywood or other local celebrities are in trouble with using some illicit substances, we normally say they have to go to rehab. Is mentioned as rehab in such a way that you're thinking it's a rehab is a full name of the whole process itself. So in insolvency, when you have had too much of debts and you've been declared insolvent and your estate has been sequestrated, you'll have to undergo what is called rehabilitation. Or you can sit back and wait for 10 years, and then the law allows that you will be automatically be rehabilitated. But that may not help you when you pop into a store or when you're trying to get credit. They might ask you for proof of your rehabilitation. And when you're citing the law, for example, saying that Section 127A of the Insolvency Act is applicable, and therefore, after a elution of a period of 10 years, have been automatically rehabilitated. The other people may not know what you are talking about. So the formal way of ending rehabilitation, rather than sitting back in terms of Section 127, capital A, is to bring an application. And our law requires that the insolvent, the person who has been declared insolvent, will have to make such an application, or they can appoint an agent if they can. That is when they're overseas, but that gets complicated. So they have to apply for rehabilitation in the same court that granted the order for the sequestration of their estate, the order for their insolvency. But even if these people were married in community of property, what is now has to be determined by the court is not the estate, their estate, because their estate has been sequestrated, firstly into the hands of the master, and ultimately under the control of the provisional trustee and finally trustee. That is out of the way. So what it will be before the court is their status as a person, their personal status. So therefore, the husband and wife that may have in the meantime separated, maybe insolvency might be the reason for the separation, that don't have to jointly apply. They individually have to apply for rehabilitation. But obviously, even if you're relocated, you have to come back to the court, which has granted the insolvency or sequestration order. It applies both voluntary surrender or compulsory sequestration. And is through the Insolvency Act. Partnerships, obviously, they cannot be rehabilitated. Insolvency is the end of a partnership, one of the grounds for termination of a partnership. And obviously, companies and CCs cannot be rehabilitated, but we'll soon later be talking about business rescue. comparable but not the same. How do you bring about? Obviously, rehabilitation is a discretionary relief, but that it means the court is not obliged. The court has to assess. The court has to play the role of a hypothetical business person, because mostly it affects the economics or business affairs of an individual, natural person. How do you go about it? Is you've got to find a provision that applies to your client's instance or your instance. You cannot just go to court and say rehabilitation. You've got to look at section 124 and see which of the provisions there your client or yourself or whoever can bring the application under. For example, if you have done composition, which we'll talk about in a few minutes, and you've offered your creditors at least 50 cents in the rand, that will qualify for rehabilitation in terms of section 124.1, which is a quicker form of rehabilitation. You give notice, I think 6 weeks notice to the trustee and the master, and off you go. The another method, which is a longish method, is after 4 years, then there are provisos, provided there was no contravention or offense under the Insolvency Act, provided that you are not previously sequestrated, provided that an L&D account is linked for inspection for at least, I think it's a 6 months. I can read out the provision, but you can also find it out, 124.2. And then there is instances where, for example, no claims have been proven. Then you'll use 124.3. Why will there not claims proven? That is where the creditors are afraid that there may not be anything in the estate, and they may be asked to pay what is called contribution. In other words, this estate is too broke to pay for itself, and therefore creditors are discouraged, because instead of receiving a check, they may be asked to write a check. Okay, I've been saying this over the years, checks are no longer applicable since, I think, January this year, but you get the sense of what I'm trying to communicate. So if no claims are proven, then rehabilitation will be in terms of section 124.3. You don't have to wait for 4 years, but obviously you'll have to, you can only know that claims have not been proved after the second meeting of creditors, because then that is the official final period when claims can be proven against the estate, barring any special meeting that may be called, any special or general meetings that may be called. But the first and second meetings are those that are statutorily there to prove claims of creditors against an estate. So although it's quicker, rehabilitation in terms of section 124.3 has to await the lapse of those time periods and those activities before you could use it. Then there's another one, 124.5, which is all claims have been fully paid. This one also is surprising. How can claims be fully paid when we're talking about insolvency? It could be an instance, for whatever reason, one again being fear of contribution, that only few creditors have proven claims, and fewer than what was there when actual insolvency was shown or factual insolvency was shown. And then therefore, whoever proved their claims, they've been paid. Then when that is the case, you can use 124.5, or else use wait for 10 years, no application, automatic rehabilitation, section 127A. How do you go about the actual application before we get to the effect? I call it it's not appearing on the slides, I'm just saying it from what the practice is. When you draft a rehabilitation application, you must have before you the application that's set before the court to bring about the insolvency, be it the voluntary surrender application or the compulsory sequestration application, because you'll need to tell the court the reasons why there was a declaration of insolvency, the order. And you can't say to the court in your rehabilitation founding affidavit, or I'll attach the affidavit or relevant documents from the court from the time when the court granted the sequestration order, and the court can refer to it as if it's specifically incorporated. No, you got to reflect the before, which is what led to the insolvency. And then you can still put to say if the court wants to see that, because you're going to summarize, you're not going to regurgitate the whole lot. You say if the court wants to see the full picture, the papers will be made available at the hearing. Now with the Joburg courts working on case lines, you might as well put it on the side and upload it, because it's no longer having the hassle of having to get court files and the like. Then the before is the application. The during is what happened after the applicant for rehabilitation was declared insolvent. What happened after the estate was voluntarily surrendered? What happened after the compulsory sequestration? Obviously, the person will have had no access to credit. Then you'll have to mention the job that is the person is doing, how much income, and how the income is dispersed. And you'll be amazed that most of these applications will reflect an amount of considerable amount being called contingency. Like a person earning about 15,000 rand, having a 2,000 rand contingency at the end, as if they've got nothing, they don't know what to do with it. But obviously, I think the reasons to convince the court that this person is now good with money and is even able to accumulate some buffer against insolvency by way of contingency. But whatever you state, remember at the beginning we said this application are discretionary. Other than meeting the formal statutory requirements, the court has a discretion to see to it that it doesn't let back into insolvency the person that may not be in reality solvent. So they'll look at the assets and liabilities that have been accumulated, but basically the income and expenditure. So you'll attach pay slips and a table or whatever showing how the monthly income is spent. And then also, obviously, how you've been living your life in as far as debts are concerned. The usual allegation that has been made is, or that is normally made, is that I'm no longer using credit and I'm using cash. Yes, you cannot really have access to credit or cash when you are unrehabilitated insolvent, because you need the permission of your trustee to enter into contracts, or the consent of the trustee to enter into contracts. All those put a limit or breaks to access to credit. And even creditors are averse, obviously, of the status of insolvency. And therefore, yes, you're bound to have operated in cash and with no access to credit. But all that you put, and then after you say, now that I'm going to be allowed back, then you address the very reasons why the applicant ended up being declared insolvent in the first place. To say those reasons, the court has got no reason to fear that there will be a repeat to that if the applicant is rehabilitated, because the following, I've taken care of my shortcomings. I'm now a member of some church, and the church has been allowing me to keep the collections, and I've been very good with that. You'll be amazed at the kind of example that have been given to convince the court that the person have rid themselves of their bad habits and as far as debts are concerned. But whatever you say, the court will be the arbiter of that and then determine whether there is a success. Rehabilitation can be granted with conditions. to say you must repay some of the debts, you must repay whatever contingency, not contingency, sorry, contribution that has been paid by your debtors, or it could be any other condition. But what it signifies is once the order is granted, it is the end of the insolvency status of such a person. And then the person can move on. But don't confuse this with the beginning of a new estate. The new estate will have began after declaration of the old estate. Because when a person is alive, they have an estate. Even in insolvency, the income and expenditure is an estate. So the second estate will have begun after the declaration of insolvency, either through voluntary surrender or compulsory sequestration. But that has no bearing here, as I mentioned, it's only the status of the person, which will now be a new one, which is a rehabilitated insolvent. Just to obviously know, or make us be aware that you were once declared insolvent. So you will be referring to you as a rehabilitated insolvent. But otherwise, if we're not being funny, you're just a solvent person. It may discharge all debts due that arose. Yeah, it discharges all debts due that arose before sequestration, except for where there is fraud and foreign debts. If you got debts from another jurisdiction, they won't be affected. It has got no effect on liability as surety. It will still continue because that liability is personal. Okay, that's the end of rehabilitation. Obviously, questions that are there that are not burning questions, they could wait until the end. Then another method which could come before rehabilitation is entering into a deal, making a deal with your creditors as a debtor. It's called composition, and otherwise referred to as compromise. I don't know why two concepts are used, but they basically mean the same thing. Our Insolvency Act refers to composition, whereas the common law refers to compromise, and it's called common law compromise, but you can find people saying common law, a statutory compromise or statutory composition. Don't be bothered about the text. How does this work is basically an agreement that is entered into between a debtor either facing financial difficulty that is without insolvency or after provisional or final sequestration has been granted. At any stage, it can be entered into. How do you go about it? Once that we're going to talk about, okay, let's talk about common law compromise. The common law compromise one is the one that is done without following the mechanics or mechanisms in the Insolvency Act, Section 123. But that one means everybody, all the creditors have to agree. If you convince 99.9% of the creditors, but one creditor is left out, then that will be, there'll be no deal. So the safer one is the statutory composition, which is dealt with in terms of Section 119 to 123 of the Insolvency Act. And it's only done through the trustee who's got to convene a meeting. He may refuse to do so, and then you will have to appeal to the master and then to the High Court to call a meeting. Because if the trustee is convinced that the offer that you're going to propose to the creditors, they're likely to refuse it, it might just not convene the meeting, because otherwise a waste of resources that are quite scarce in insolvency. But otherwise, if it's convened and 75%, 3/4 in value and 3/4 in number. So you can convince the bigger guys and to the disadvantage of the smaller guys. It's both in value and in number of the proved creditors, because we can't deal with anybody who's not on the table or hasn't proven their claims. That is why at these meetings where composition is being considered, the first business to happen is to allow creditors who have not proven their claims to do so, and thereafter they participate. If 75% says yes to the offer and they accept it, then there is a contract, there is an agreement, and then the estate will be managed in terms of that agreement. And normally the trustee who has been appointed will be the ones who sees to it that the agreement, because obviously the debtor, insolvent debtor, will have made an offer, and then 75% approved creditors in value and number will have accepted the offer. The offer will become a binding an agreement or a binding composition between the debtor and creditors, even those that voted against, and even those that didn't prove any claims, they'll be bound. So once that is in place, then the trustee will make the contents of the whatever was agreed upon, put it into effect. It might involve, for example, where a debtor is trying to pay less. It's offering his creditors to say, hey, I've got a rich uncle who's going to give me money as guarantor. Is making money available. I'm going to pay everybody quickly at once, 50 cents in the rent, and you return back my assets. Or it could be that, oh, okay, I'm going to take this asset that you have sentimental value to me. When you're going to sell them at an auction, they'll mean nothing. I've got a new job now where I'm getting more money. I'm going to pay you in monthly installments back into the trustee who will distribute it accordingly. Please release my assets. It could be any condition of the offer which has been accepted, but as long as it's not contra bonus mores, or it doesn't come with guarantees that the person will, the creditors will consent to, for example, rehabilitation and all that. Okay, that's the end of composition, and then with that end of sequestry or natural persons insolvency. Let's quickly get into liquidation of companies, which is not as complicated, if I can call it that, as sequestration and voluntary surrender or sequestration of insolvent estate. As I've mentioned, what is going to keep us busy is insolvent estates, particularly insolvent companies, particularly companies unable to pay their debts as and when they become due. The law for that is still the Old Companies Act, Chapter 14, which is kept, despite the repeal of that act through item 9 in Schedule 5, is still kept alive. The other sources of law is, as I put them on the table, they're similar to the other topics that we already have dealt with, but there could be more. How does it come about? Okay, I'm saying insolvent companies, Chapter 14, and then you remember Section 339. There's also solvent companies. We're not going to deal with that. You will know when a company is solvent, and then you can use the following. We're going to deal with commercial insolvency in a while. But assuming you are dealing with liquidation of insolvent company, your point of departure will be Section 344F. You remember Section 344 deals with grounds under which a company may be wound up. If I may quickly refer you to what it says to give you, I've already mentioned this Football World Cup company, but here it is. It says circumstances, that's Section 344 of the 1973 Act. It says circumstances in which a company may be wound up by the court. A is a company has by special resolution resolved that it be wound up by the court. And then D, it says in the case of public company, the number of members has been reduced to below 7. Then F says the company is unable to pay its debts as described in section 345. So that is what primarily is going to concern us. And that is normally what, when you hear a company has been, let me use the word compulsorily liquidated as opposed to voluntary liquidation, will be the cause. That is inability to pay debts. How do you determine that a company is unable to pay its debts? Do you use the same methods that you used for natural persons? You remember we had that table of liabilities on the one side and assets on the other. No, it doesn't work like that. No actual insolvency. With due respect to the courts here and there, and I've been a number of times been turned back where the judge of the day will be thinking actual insolvency is a requirement. No, you don't have to know the assets of the company. If companies were to be liquidated due to their assets being less than liabilities, it will probably be almost every company, because when you have a business concept, I remember years ago I received a sort of prospectus in the mail or some invitation to invest money by this company that said they're going to, probably they've already done it, I don't know. They're going to develop this trailer that won't work like your normal trailer. When you talk about trailers to the to cars, to motor vehicles, your Fender trailer and there are other brands. When you reverse, they say, imagine yourself being in the Kruger National Park, and then you have been charged by this elephant bull, and you got a trailer and you got to reverse quickly. How do you do it? You know, when you reverse a trailer, it's got funny in where you drive. You got to drive as opposite from when you're going forward. But they say this trailer, no, you don't have to. This company said they're going to come with a trailer which you drive normally. When you reverse backwards, when you turn like you're driving a car without a trailer. And they say this is going to sell like fat cake, Manamela and others. Please invest in this company. So such companies, instead of doing that, they can go to a bank and borrow money for the brilliant idea that they have. So what they're going to have is they're going to have a liability without probably assets. They can use the money to pay themselves salaries. After 6 months, the money is gone. They pay themselves salaries. They've got only liabilities and no assets. But they're not commercially insolvent as long as they're able to pay their debts as and when they become due. If they fail to do so, such companies are commercially insolvent, meaning they are unable to pay their debts as and when they become due. It doesn't mean that they've got fewer debts than assets. They may have zero assets, but as long as they're able to meet their obligations in terms of the stipulations in the contracts, there is no commercial insolvency. There is no reason to liquidate such company due to inability to pay debts as provided for in section 344F. How do you go about proving that a company is unable to pay its debts? How will that happen? Section 3451 is the mechanism. The one that is very popular is by sending the company a letter of demand and giving the company 3 weeks period to pay. And if such company fails to pay within 3 weeks, then it should be presumed to be unable to pay its debts. How does it work? You have to get the letter of demand delivered at the registered office address of the company. That's basically bring about a presumption that it is a correct place. And then it's delivered in the sense that it must be received. So your email may not necessarily work, but the courts are quite courts of equity that might allow that. Normally what I do, I'll have it delivered through the sheriff. So you, in the letter is a normal letter of demand, save that you have to state that your client is a creditor who's owed at least 100 Rand liquidated claim. Sound familiar? Yes, we have dealt with this under compulsory sequestration. 100 Rand liquidated claim. It gives you locus standi to bring an application for the liquidation of a company on the basis that it's unable to pay its debts, just as with compulsory sequestration. And then you have to state that how the debt arose, which is basically how the claim arose, the contracts, whatever. So you're pleading in as far as that particular claim is concerned. You can't just rush and say, yeah, it's been owed 100 rand and that's it. It's got to be the 100 rand is for goods sold and delivered. Proof must be delivered of the contract and the delivery and everything to say, to make it, to avoid any dispute as to the liquidated nature of the claim. And then you have to say that this is a letter of demand in terms of section 134, section 345 1A of the Companies Act 61 of 1973, which is the old Companies Act. And that should the company fail to pay or compound basically meaning to enter into a acceptable arrangement, the debt, then the company will be presumed to be unable to pay its debts, and therefore a liquidation application will be brought. Often this type of letter or this provision is abused to arrest credit debtors, but you need to use it when you really mean it. Otherwise, abuse of the law. Do you need to show advantage to creditors? No. Advantage to creditors will have to be, as we have stated before, that is following. Is it? The advantage to creditors that we have to do, okay, maybe let me just start by saying this. There is no requirement to show that liquidation will be to the advantage of creditors. But their courts, and I think even the practice manual alludes to this, will need to know that this particular creditor is not on a mission of its own to benefit itself to harass the particular debtor. So what is normally been stated is that what I've already said under compulsory sequestration, that liquidation of this particular insolvent company or the company that is presumed to be insolvent or unable to pay its debts will benefit creditors in the sense that a liquidator will be appointed who will see to it that assets are liquefied or liquidated to pay the or settle the claims of the creditors in terms of law. That is basically what has been said. It's not a requirement, but I got turned back, I think about twice by the court here in Pretoria, saying where is your advantage to creditors? You just have to make the amendment, but it's not a statutory requirement. And you don't have to show dividends that is likely to be obtained. Okay, so what is it? Okay, maybe I need to mention again, sometimes the confusion comes whether you act of insolvency is applicable. No, it's not applicable, but I've seen it in judgment. And I think I've also got a matter where somebody had said act of insolvency, and we said, no, there can't be an act of insolvency. And they succeeded against my client. Acts of insolvency they only belong in natural persons, compulsory sequestration. So here is only presumption of inability to pay in terms of section 3451A, which is the letter of demand. Then there's 3451B, another presumption, which is a nulla bona return. Obviously, where there's a nulla bona return, it presupposes that there was a process before and then judgment was obtained. And that judgment, there were no assets or no sufficient assets to meet the judgment, and there's a nulla bona return. Then 3451C is almost a catch-all. Any other reason that you can state to the satisfaction of the court that a company should be presumed to be unable to pay its debt. So the law has kept it open for the courts to listen and determine whether there is ground to presume a company unable to pay its debt, and then grant such an order. Okay, then security for cause, yes, you got to do it as with compulsory sequestration. Master's report, no. I think in Cape Town they say it may be, but I'm not aware of that. Notice to the debtor company, yes, unless it's so urgent that you can't give notice, which you'll have to convince the court why the notice requirements in terms of section 6 or the provision section, uniform rule 6, sorry, were not met, and also the practice note as to agency, whether it's going to be had as very agency on the Tuesday or whatever, the file has to be in by the Thursday. Now with the uploading here with case line, I don't know when is the cutoff date. But you got to take care of all those practical issues. But notice to the data company is a requirement unless you can show the code why it should dispense with such notice. Notice to other statutory interested persons, your regular suspects, so to speak, registered trade union and employees, or only employees if there's no registered trade union, and SARS. Notice to creditors, and now there's no requirement. I remember vividly that was an application of mine where the judge, for whatever reason, says there was no notice to creditors. And it was postponed. We had to go back because we don't have the list. All what we did, we sent through a letter to the director and said, give us a notice of your creditors because the court requires us to give notice. Your guess is as good as mine. The director said, didn't oblige. We went back to court and said, we are not aware of the creditors except ourselves, and therefore we can comply with the order in as far as that part is concerned. But obviously the next judge was quite surprised, and he or she agreed with us to say it's not a requirement. You don't have to notify creditors, unlike in voluntary surrender, where you had to publish in the Gazette and also send a notice within 7 days of publication in the Gazette and the local newspaper. Okay, yeah, I'm dealing with advantage creditors. I've already spoken about that. Say it's not a requirement. But if you convince the court that you are not bringing a vexatious litigation, that might help. Often or not, business rescue is being used to stifle liquidation. And the typical averment that has been made to avoid liquidation is to say that employees will be in the streets, and therefore we must give business rescue a chance. It normally in a situation where we are in our country, and as far as unemployment is concerned, that basically sells. Then other modes of liquidation could be voluntary winding up by the court. But then there's members voluntary winding up, which is by special resolution, with documents, the special resolution filed under prescribed forms with the DTI or the registrar, the Companies and Intellectual Property Commission or CIPC. For members voluntary winding up and creditors voluntary winding. The members voluntary winding up should only be in case where there are no debts or the security for those debts, but they sometimes get confused and get granted, get passed and registered and without necessary compliance. But the CIPC is obviously slowly improving its systems to make sure that doesn't happen. I've already spoken about other grounds of liquidation other than insolvency. Yes, in Section 344, there's many. And also the new Companies Act in those sections under Part G of those chapter, you can you can liquidate companies on the basis other than insolvency, therefore solvent reasons. Liquidation of closed corporation is as quick as it appears there, is the same as with companies, only that it can be done in the magistrate court and the high court. So since we have started this morning, is the only time when we can go to the match court. That is when we want to liquidate a closed corporation. There is no guidance as to how to make a choice, but you cannot run away from your local magistrate court to the high court. Some people say the size of the estate, but it's not necessarily a requirement. The law allows you, I think, convenience to where the creditors, most creditors will be what will govern whether you're going to the district magistrate court or the high court. Instead of Section 344, you have Section 68, sorry. And instead of Section 345, you have Section 69. There was when the act was amended, there was a taking away of whatever, but you can use, I know now you can use Section 345 or cite for liquidation of CC Section 345 as it is, by virtue of the Schedule 3 and Schedule 5 of the New Companies Act. But the requirement is basically the same. Presumption of inability to pay is 61A, 61B, 61C. That is, instead of saying 3 weeks later, it says 21 days later, the letter of demand. B is the nullible bona return. C is the any ground to the satisfaction of the court that a close corporation is unable to pay its debts. Yes, primarily your act, the legislation will be the Close Corporations Act, but as you've seen, you can refer through the Schedule 3 read with Schedule 5 to the 1973 Act, where the Close Corporations Act doesn't apply to, or doesn't have a provision for in respect of CCs. That is basically the end of liquidations. The consequences of liquidations are that you can't transfer shares, but wait a minute. Shares after the commencement of winding up, they say is void, but they are valueless. Because once there's winding up or liquidation, creditors come, they come first, and then your shares are basically, unless there's a surplus, they're worthless. But they say you can't transfer. I think it's basically to avoid complications with regard to companies where the liability will have attached the shares. Dispositions made after commencement, yes. Dispositions of assets, they are which are not in the ordinary course of business, they are void. You cannot start paying or preferring one credit above the other, or transferring assets, or maybe let's say there was a transaction that was incomplete and used where the transfer of a movable property has to happen. If it happens after liquidation, it is void. All civil proceedings are suspended until after the appointment of a liquidator. Okay, be careful. You will know when you're dealing with natural persons, in sequestration of natural persons or their estate, you're dealing with trustees. When you're dealing with liquidation of companies and CCs, you refer to the persons in charge as liquidators, provisional liquidators, or just liquidators as in final liquidators. So don't say trustee when you're dealing with a company, or liquidator when you're dealing with a natural person or a partnership. But they don't really, it's not a train smash. Attachment after commencement. Commencement of winding up is upon presentation of the papers to the registrar. That is quite important, because anything that happens thereafter is, as a disposition, is void or transfer of shares. And also there can't be any execution and without the order of a high court authorizing same, because otherwise it's going to disadvantage other creditors. Directors will cease to be in charge of such a company. Then basically that concludes liquidations. We will still, at the end, for those that are prepared to stay behind, spend a few minutes. I'll give you some of the laws cases that have happened, especially with that famous company, Wasasa, it's now called African Global Holdings. Okay, business rescue is quite a detailed topic. It obviously somewhere else we offer it as a day course, but here it's a catch-up seminar or webinar. What it is that Chapter 6 governs it. It came through to improve on what was there under the 1973 Act, which was judicial management. Judicial management didn't do well, although we were one of the first countries, the first country to come up with it, but probably it wasn't given a chance. Business rescue has been utilized. It applies to both companies and closed corporations. It doesn't apply to all businesses, which are not companies or CCs, despite the name being business rescue. And your source, yes, is Chapter 6 of the New Companies Act. There are other textbooks as appearing on the screen. What is business rescue? As it is a method by which the legislature has thought there could be some intervention to help. And perhaps what I need to do is to refer you to the meaning of business rescue as appearing in the act. That has got a link basically to what I'm going to say next. Business rescue is explained as I'm reading out from the Act itself, Section 128(1)(b). It says, proceedings to facilitate the rehabilitation of a company that is financially distressed by providing for Roman figure 1, the temporary supervision of the company and the management of its affairs, business, and property. Roman figure 2, a temporary moratorium on the rights of claimants against the company or in respect of property in its possession. 3, the development and implementation, if approved, of a plan to rescue the company by restructuring its affairs, business, property, debts, and other liabilities and equity in a manner that maximizes the likelihood of a company, okay, pay attention, continuing in existence on a solvent basis, or if it is not possible for the company so to continue in existence, results in a better return for the company's creditors or shareholders than would result from the immediate liquidation of the company. So you're achieving business rescue if you turn the company around. I'm using words that don't come from the Act, to continue on a solvent basis. But listen to this, you're still achieving business rescue if you could do whatever that will result in a better return to creditors than would the immediate liquidation. The latter part of business rescue meaning is the one that we call a super liquidation or business rescue, liquidation business rescue, where what happens is that instead of turning the business around from its distressed, a financially distressed position into operating or continuing on a solvent basis, you simply shut down the business and then start selling the assets. And then as long as you are able to show that creditors will receive more than they would have received in liquidation, then that is still called business rescue. It doesn't sound proper business rescue, but it is what the law had said. There are talks that it might be changed to read something else, but it's still that is the case. So meaning even if you don't turn the company around, but you lock it down and you sell it, and creditors get a better return than in liquidation, which is normally likely to be the case because you can agree the fee that is to be paid as a business rescue practitioner that is appointed. And you can also save cost in as far as, for example, storing the assets and all that by entering into better deals. Some of the creditors can be allowed to take back their assets and give you money in return and all that. And then you are able to run it better as long as you show the result that is better than liquidation. It is business rescue. But enough with the complaints. Let's move forward. What does it do, business rescue? Is either it rescue the business, and it also creates a moratorium in as far as claims are concerned, which means that basically you cannot, the repayment of those claims is facing a period of grace or moratorium. What are the requirements? There must be financial distress. It is explained in the Act. It is basically as the test is as stated under Section 128F, 1F, sorry, 128, 1F, the meaning of financial distress. Meaning of reasonable prospect of rescuing the company, basically is what I've read out to you under B, which includes super liquidation, as I've called it. Alternative to liquidation, that's basically what I've said. When you can show better return, it is business rescue. But obviously, the primary purpose is if you can turn the business around, but sometimes it's not possible. How do you place businesses or companies and CCs rather in business rescue, special resolution in terms of Section 129, or court application in terms of Section 131? The 129.1, you cannot place the company in business rescue by way of special resolution if there's pending liquidation. One of my clients, while we were defending a liquidation against his company, behind my back, went and found somebody who convinced him that he can pass a special resolution under Section 129. He had forgotten about the application because it was lying in limbo. He filled up all those forms, lodged them with the special resolution with the CIPC, and then only later when the business rescue practitioner contacted me, I told him that no, you can't because there is a pending liquidation application. And that was obviously a source of bad news for both my client and the business rescue practitioner. Otherwise, you can approach the court, which is what we call compulsory business rescue application in terms of Section 121. Then ultimately, the person who is appointed to be in charge is a business rescue practitioner. Initially, when this thing started, they were licensed as and when they go on a company base. Now you get to the you apply to the CIPC, you are graded. If you're unhappy, you go to the company's tribunal. But otherwise, you'll be a certified business rescue practitioner or licensed. You're licensed if you meet the requirement Section 138. You can either be a senior practitioner that has got a bearing on the companies for which you can be appointed, and ultimately the size of the companies, and ultimately the amount of money or fees you can charge, the rate you can charge. And then the experienced practitioner, yes, somebody in the middle, and then the junior practitioner. In our olden days, I think at school, we dealt with a story about the ghost that had to cross the bridge and had to meet the giant by the bridge. They're called Klein Boetibok, and Groot Boetibok. So when I say this, it reminds me of that. The junior practitioner, Klein Boetibok, the experienced practitioner, Boetibok, and the senior practitioner, Groot Boetibok. I hope my joke is funny, or else you'll find it funny later on when you are alone, away from the stress of this. The remuneration, as I mentioned, it goes with the company size, and basically also, excuse me, the person who's appointed with the company will be either it's a business rescue practitioner, experience, or senior. We don't have to go through that. You can find all that. The remuneration, there is no limit or restriction to any further remuneration. There could be agreements. Most of the time, what practitioners work on is on a success fee rate, which have to be obviously be part of the agreement with the plan, the plan that has been approved, or the plan that has been adopted. The process itself, obviously, is as it is the business rescue process. It comes, and then there will be a plan. The plan is provided for. Sorry, the guidance of the plan is provided for under sections 150 to 154. It's normally what you can use as well for composition and compromise for natural persons. I've used it. It tells you what has to be contained in your rescue plan. Is the bottom line. You can include more. And then that plan has to be presented for adoption. And then if the proposal, obviously is a proposal, if it's accepted, then it will be what is called an adopted business rescue plan. The number or the figure that has to be used for the adoption of the plan is almost the same as the one that we had for compulsory sequestration. It's let me just get you the exact wording that has to go for a vote in favor of the plan or against. If it doesn't reach the threshold, then is going to fail, and then you have the provision of doing it again. You'll see if you find time now. I will give you examples of where it was the plan failed, and then it has to be done again, and then the plan failed and it has to be done again, and the question arose as to how many times you can do this without basically the whole process being regarded as having failed, and then liquidation as having to be allowed. Section 152(2) says that the votes have to be okay, maybe let's start with section 152(1). My eyes are failing me, but 75% of more creditors' voting interest were voted. And then of those 50%, there's got to be independent creditors' voting interest. Of the 75% that is to vote of voting interest, 50% of those are to be independent voting interest. What constitutes independent voting interest is defined. You go back to the beginning of your Act, Chapter 6, sorry, which is Section 128. 1J, voting interest means an interest as recognized, appraised, and valued in terms of Section 145(4)-6. These things are quite practical, although obviously business meets the law in business rescue, and therefore some of the practitioners, when they go, they get appointed, they bring in, they either retain the directors, because upon the granting of a order, directors they cease to be in office, and then they can only be involved, although they are obliged to assist the business rescue practitioner. They are not necessarily to be employed, but it's advisable to retain them because they are the people who understand the business, and normally they'll guide through the business, although they often not, they might here and there become stumbling block. You don't necessarily have to include directors, but it could be any person that was quite influential or involved in the business and can guide the rescue process once there's an adopted rescue plan. Once then as an adopted rescue plan and the substantial implementation, the business rescue practitioner will file such a certificate and moves out, and then the business is handed back to whoever it needs to get back to, be it directors or management, to continue. There is what is called effects of business rescue on employees. For example, the suspension of the contracts and the termination. And I've already mentioned about directors and shareholders, Section 136 and 137. Then compromise with creditors is almost like business rescue, is governed by Section 155. It's almost like a compromise statutory composition in terms of Section 123. But it follows the proposal follows the form of the business rescue plan, and the majorities as well of voting for the plan also correspond as those in business rescue. It says here, section 155, 6, a proposal contemplated in this section will have been adopted by the creditors of the company or the members of a relevant class of creditors if it is supported by majority in number, representing at least 35% in value of the creditors or class, and case as the case may be present, and voting in person or by proxy. So here you're not dealing with voting interest as in business rescue. You're dealing with creditors because Section 155 governs a compromise between a company and its creditors. So it differs with the voting interest in business rescue, which goes to affected persons and more, and is specifically defined. So the format of it is basically an offer and acceptance, which forms a contract in terms of our law, as long as the majority is met, and then the implementation thereof could be by way of a receiver or anybody that has been appointed to in terms of the proposal or the compromise plan. That is basically the end. I'll allow for questions before I say something more on my own. I think your mics have been muted, so you'll have to probably raise your hand, or let me see if I can. Is that part of the meeting where you start saying something? Yes, Chris, let me see. There you can go. Oh. No, wait. Sorry, Mr. Van Dijk, just a second. Lower end, make remove the meeting. Okay, go ahead. Mr. Van Dijk? Yeah, okay. Let me see if I can try and change everybody's status. Ms. Fakuda, are you listening, or Ms. Makanda? To help me here
sir,
quickly.
we are listening. What do you need help with, sir?
Just enable everybody's mic at a go. Can that be done? Everybody. Sorry? Yes. Can it be done? Everybody at once?
I'm trying, sir. Just please give me a second.
Okay. Mr. Van Dijk, I think you are on. Or not? Just 1 second. Trying to find it. Yeah, I see all the hands are up. While we're finding that,
So, Mr.
sorry, I don't want this to come on the screen.
Mr. Van Dijk's mic has been unmuted. He can ask his question.
Yeah.
Hello, sir. Can you hear me?
Okay, Mr. Van Dijk, go on.
Can you hear me, sir? Hello?
Yes, loud and clear.
Awesome. Just a question on the value of debts on voluntary surrender. There's two elements that I would like to have your view on. The
Yes.
one is, I'm not a conveyancer, but my understanding is when you register a bond, there's also always an additional amount that forms part of that bond. Is that included or excluded in the liability? That's the one question. The second question is, what about interest accruing? How do you deal with interest? Because you may put in a liability of 200,000, but you've got a running interest component. Just your views on that, please.
Yes. Okay. Let's start with the amount, the capital amount, or normally called what is it called? Main amount and additional amount, principal amount and additional amount.
Yes.
When is not as complicated as it will sound. When you deal with it from, say, voluntary surrender point of view, you remember we say debts are fairly estimated. You'll work on what your creditor will say. The normal thing will be your statement of account, which will show the interest as accumulated at a particular date. Remember, the additional amount thing in the bonds is to basically help the creditor to remain secured for the amounts that are beyond the principal amount on the mortgage, in terms of the mortgage agreement. Am I right on that?
Correct. Yes.
Mr. Van Dijk?
Yes, correct.
So what you consider in as far as insolvency is concerned is whatever is due and payable at the time. But is basically a fair estimation. It doesn't have to be 100% accurate, but obviously, if you are aware of interest, you can exclude it. It will be what is due and payable as at the time. But putting it in a practical terms, it will be what your bank, when you receive a bank statement, it will show what interest that accrued at the particular point in time. Then you can use that. Or else, if you want to be accurate, you can ask for the bank to give you, what is it called, release figures?
Yes.
And then they give you those figures and you use that. But normally you'll use a normal bank statement.
Thank you, sir.
Did I answer both questions?
Yes, you did. Thank you.
Okay. Anybody else? AG is, let me see again if I can.
Sir, I have managed to unmute on all mics, so delegates can go on and
No,
ask
thanks a
questions.
lot. That's perfect now. That's perfect. Thanks a lot. Adrian, I can't see the full name. Adrian Keith, and perhaps the same name. I see you're still muted.
Hi, good morning, Mr.
Yeah, you're on.
Mela, can you hear me?
Yes, I can hear you.
That's perfect. First of all, thank you very much for giving us your time today. I'm sure a lot of us will agree with the sentiment. We really appreciate the knowledge. Just with regards to the presentation, was largely based on, application from, applying for liquidation matters and the requirements thereof. Could I maybe just ask you to give us maybe a general short overview when it might be relevant to defend such type of applications, specifically when you have a client that's started a business and things haven't gone great and they've accrued a lot of debts. Is there sometimes an advantage to defending these types of applications, or rather letting them just go through the court system undefended? Maybe with like that sort of scenarios.
What will basically be the ground? What will advise such a decision in, as far as I'm concerned, will be obviously when a company that you had started faces liquidation, sentiments will come into the play. But the reality is that is either the debt. Let's put it in our back into what we have shared today. say there's presumption of inability to pay debts by way of that section 3451A letter of demand. Your client didn't react to it within the 3 weeks, but then it's now facing liquidation. You simply can defend it by saying, no, we have more, we can be able to meet this particular claim of this particular client, and therefore there's no need for presumption of inability to pay debt. What I mean is that you've got to defend it from the angle that whatever is being alleged in law doesn't have a basis. A typical defense these days is to say that the business is not doing bad in terms of its, I would say, concepts or business objectives, but is probably facing some temporary financial problems, and therefore you can invoke, as a defense to liquidation, you can invoke business rescue and say the company is financially distressed for now, and it will, given a chance, it will be able to be rescued, and it meets the definition of business rescue as in section 128. So to defend it simply because your client dislikes liquidation may not be advisable, because right at the end, the cost for such defense may not be the cost in liquidation. And your client, wherever your client may have found the money, it could have to get funds from elsewhere to pay for its own lawyers, as well as even defending the ill-advised liquidation. But the defense of either sequestration or liquidation has to be on the basis that either the requirements of the law, namely substantive requirements as opposed to procedural requirements, although procedural requirements do matter, especially for voluntary screening, to say those requirements have not been met and therefore the application cannot succeed, or else the debt is not due and payable or liquid in as far as substantive requirements are concerned. But otherwise, all in all, when a company faces liquidation, the best outcome is business rescue if it could be justified. Thank you.
Thank you, sir.
Did I answer you, Mr.? I can't see the same, Adrian?
Yes, Mr. Manamela, that sounds perfect. Thank you so much for your answer.
Okay, somebody else? I see Nazir Pierre. You're still muted, sorry. Let's see what we can do for you.
Can you hear me?
Oh yeah, there you are.
Yes, thank you so much, sir.
Sorry, before you come through, is it Mr. Pierre?
Yes, sir, that's correct.
We will go over 1 o'clock. I'm sorry it is extending over 1 o'clock, but those that will want to go, it's fine. We will. I'll have additional material by way of recent cases that I will distribute to you through lead in a matter of weeks or so now. It will just be a guidance of cases like the African global one that I've mentioned, Mazonga that I've mentioned, that have been handed down in the last 24 months in our courts. The major ones, especially from the Supreme Court of Appeal, and you've seen there was the Shiva uranium one that went through to the SC, to the Concord about a few weeks ago. Okay, Mr. Pierre?
Yes, thank you. Okay, so I have basically 2 questions which are sort of procedural in nature. With regards to liquidations of companies, so you obviously, have your respondent being the debtor, and then by means of serving on other interested parties, being SARS, trade unions, etc., does a copy of the application have to be served on those interested parties by means of the sheriff?
No, the notice has to go to them. The actual application has to go to your SARS. Yes, you got to serve on them. and have proof, you are registered trade union and your company. Oh yes, I said no, and then I'm saying yes. So there, you send through a notice in as far as your voluntary surrender is concerned. That is where you're required to send a notice alone.
Yes.
Are you with me?
Yes.
And then the actual application of that, remember it's still called a petition, doesn't go there, which is awkward. But then in as far as that requirement is concerned for compulsory sequestration and liquidations, yes, you only serve the application. It's got to be served the application.
Okay.
The application, the actual application on SARS, the local branch of SARS, and the union that has been identified, or unions, and then you got to display the actual application on a notice.
Okay, understood.
Mr.
Thank you.
Okay, let's move on then, Mr. Harris. Mr. W. Harris, they will enable you now. Let me just see if I can. Hello, Mike. Mr. Harris, are you still with us? I see I'm allowing Mike and then it is allowed.
Here we go. Hi, can you hear me?
Okay, it's there.
Okay, can you hear me?
Yes, go ahead.
Okay, fantastic. So I've had cases where attorneys are telling clients, prospective clients who want to go under liquidation, that they can continue with the process of liquidation even if there are not enough assets to satisfy or to liquidate in order to give a share to each one of the creditors. And they are saying that they can enter into an agreement with the trustee and the creditors on a particular client's salaries or incomes. And I just wanted to know, is that possible?
And pay it off in tranches until it satisfies the requirement.
Yes. So
yeah, no, I've met that. I've seen that. Where you will pick it up mostly is when in a voluntary surrender application, there will be a 20,000 rand in cash being kept in the trust account of attorneys. It's normally a source of raising of the eyebrows for the court, because where did it come from? I know some attorneys, they will say, we know you don't meet the requirement for enough free residue or enough advantage to creditors, and therefore pay an amount for the next 10 months to build up that kitty to be able to meet those requirements. I won't say it's illegal or legal, but it will be illegal if it is against the understanding that the client will simply abandon his obligations to creditors and not paying over to an attorney until a particular amount has been raised to be shared or to bring an application. It hasn't gotten the attention of our courts. I might be calling it illegal. Maybe it's not illegal. Maybe it's immoral only. And our courts are not courts of morals. So it just doesn't sound good. The attorney, such an attorney may not be able to convince me if I'm sitting as a chairperson of a disciplinary inquiry at the Legal Practice Council that it is above board. But otherwise, it's not something that is provided for in terms of the Insolvency Act or the Companies Act. That's all what I can say. It doesn't sound good.
Thank you.
Okay, then can we go to Claudia or Claudia? Are you able to unmute yourself? Okay, maybe let's move on to Dean Olivier. Or anybody that can unmute themselves and ask question, because I'm looking at the screen as it is a very short screen. There could be somebody who's unable to unmute themselves. Ntombi, you said that you have unmuted everybody so they can do it from their side.
Yes, sir.
Okay, anybody who can unmute themselves and ask a question? Okay, otherwise then I'm assuming, are there people still here? Because with this kind of platform, I might be talking to myself and Ntombi.
No, sir. We still
Are
have
they-
36 delegates on the platform.
Okay, quickly, let me just run through what is featured in our course. I won't be mentioning everything. Let us agree by way of housekeeping that I will be done by 1:15, so that I don't keep you for a long time. There was the SCA decision of Murray and others versus African Global Holdings. That had to do with when is voluntary winding up starting and whatever. I'll just read you the not the actual facts from the case, but the head note quickly. African Global Holdings, which was Bosasa before it changed its name, it found itself having its banking facilities withdrawn from its operations. That is after Zondo. And thereafter, it decided, okay, it's going to place itself in a voluntary winding up. And then it had a subsequent change of mind, and then it wanted to unravel the process. And that occupied our courts a number of times. So then, I mean, at various levels, and it's still, I think, the ramifications of it is still are they coming up. But then what I need to share with you from this particular decision is that the SCA basically said that in as far as the claims are concerned, I'm just trying to find the correct part that I'm shooting out for you. The High Court in Johannesburg had granted an order, or it refused basically to reverse the process. And then the SCA agreed with it to say that because the main point of contention was that the company was a solvent company, and therefore the special resolutions were basically misguided. So the court basically said the following, just as a way of, in paragraph 23, commercially insolvent companies are liable to be wound up only under the old act and could not be wound up under the new act. That is what we have dealt with. And then the test for commercial insolvency whether the company have liquid assets or readily available assets to meet its assets as they fell due. That is commercial insolvency, and to be met in the ordinary course of business. And thereafter, the company will be in a position to carry on normal trading. And then that is in paragraph 28. And paragraph 29, it says, when for whatever reason a company was unable to access liquid assets, it was illiquid and unable to pay its debts as and when they fall due. So that is the test of commercial insolvency. Then another case that that is quite recent will be recent as in 2013, the case of First One Bank and Lodi Properties. This is a Pretoria High Court case. it dealt with the meaning of a solvent company. It says basically that means solvent company is a company that is neither actually nor commercially insolvent. That is the confusion that I mentioned to you, that actual insolvency is being brought into the fray when dealing with companies, in as far as beyond assets and liabilities. But here it says a solvent company, the one that is neither actually insolvent or commercially insolvent. That is basically what a solvent company is to be dealt with under Part G of Chapter 2, meaning that those are the companies that can be dealt with in terms of the New Companies Act, as opposed to Chapter 14 of the Old Companies Act. Then that particular meaning was actually adopted by the SCA in Boschbold Ordnance under Niemens. It's not quite often that you find a higher court adopting a ratio or a ratio from a lower court. It basically here they expanded it to say that commercially insolvent or factually solvent and or insolvent companies may only be wound up under Chapter 14 of the old Act. That is, commercially solvent companies then may not be wound up under Chapter 40. That's basically what it says. And this dicta is what has been taken or adopted under the Lodi case that we've dealt with. Quickly, under compulsory sequestration, I would refer you to the case of VBS versus VBS in liquidation versus Mazonga. I think Mazonga was the CEO, where he challenged. There was the matter went to court first, and Judge Soka granted a provisional order, and then the final order was opposed, where Judge Matujani wrote a judgment, and the whole essence of it was that the debt relied upon wasn't a liquidated claim as invested by Section 9 of the Insolvency Act, because it was reliant on a circumstantial evidence or evidence that came from a testimony of another witness. And the court had the following to say. I'm reading up at paragraph 45 quickly. The inference that Mr. Mazonga participated in and benefited from the fraudulent scheme is the most readily apparent. Had Mr. Mazonga not appropriated the proceeds of the fraudulent scheme, VBS would not have suffered the loss to the extent that it did. The perpetrators' independent wrongful acts combined to produce the same damage, namely loss by VBS of the amount of at least 1.5 billion. Mr. Mazonga, as a concurrent wrongdoer, is accordingly liable for the full amount of the VBS loss. And then it goes further to say that because he doesn't have the 1.5 billion, he therefore has to be, the final order has to be made. This is where the court says that in paragraph 50, it says, he stays without any substantiating evidence, that is Mr. Mazonga, that his estate is worth more than 30 million rands. According to Mr. Mazonga, he currently only owes VBS a sum of 8 million rands plus interest. This amount consists of debts relating to a mortgage bond, 5 vehicle finance agreements with VBS. On 26 March 2019, the attorneys of VBS acting on Mr. Rupla's instruction, I think is the trustee, addressed a letter of demand to Mr. Mazonga in respect of this debt. Mr. Mazonga had acknowledged receipt of the letter of demand and does not dispute his indebtedness. He has failed to make payment of the outstanding balance. This is indicative of the fact that he is unable to repay his debt. And then furthermore, Mr. Mazonga on his version does not have assets of over 1.5 billion. He's accordingly factually insolvent. So this is quite new ground for a court where the whole 1.5 billion is attributed to one debtor. But obviously, as a requirement for local standing, only 100,000 needed to be approved. Then quickly rushing forward, if there's anybody who wants to ask a question while I'm going through, they can do so, not to wait for me, because I'm running out of the 15 minutes that I put forward. Then there's a case of Immobright versus DTL Bulgari. Is an LSCA case of March this year. That one dealt with close corporations. It's regarding Section 69 thereof, which I said is similar to Section 3451. Whether application for winding up brought by secured creditor constituted an abuse of court process, unpaid creditor are generally entitled to winding up ex debito justitiae against corporation unable to pay his debts. Discretion to nevertheless refuse winding up order, whether discretion not to grant the winding up order was properly exercised. And then the appeal was upheld. Basically, it deals with the fact that the court has got a discretion and the issue of abuse of the process of the law. With regard to business rescue, quickly, there was a case in November 2020 which concerns a Italian company, and then the whole issue was whether there could be an external company can enter into business rescue. The ultimate answer was that he's got to apply for recognition and the base for the recognition. Then a matter of May 2022 of the SCA, that's Horo Consortium versus Cedar Park Properties. That one deals with whether reasonable prospect of risking a company, as in Section 1314A, what constitutes that? And the court basically explained it to say, in paragraph 10, the applicant in business rescue proceedings bears the onus to prove that the company under consideration will have reasonable prospects of recovery. This is a factual question for which a material foundation needs to be laid out in the founding affidavit by the applicant for business rescue. And it goes further and refers to an earlier case of Kuhn and Feather. It says in paragraph 31, relying on the reference in section 1281B, the development and implementation, if approved, of a plan to rescue the company, was the reasonable prospect of rescuing the company. Okay. And then basically the court says, as I see it in the same paragraph, it is in direct conflict with the expert provision of section 128. According to this section, rescuing the company indeed requires the achievement of one of the goals in section 128(1)(b), the one that I read to you, say the outright rescue of the company or the giving of a better result than liquidation. The court went further. Self-evidently, the development of a plan cannot be a goal in itself. It can only be the means to an end. That end, as I see it, must be either to restore the company to a solvent going concern, or at least to facilitate a better deal for creditors and shareholders than they would secure from a liquidation process. So that is your section 128 brought it up as recently as this month by the SCA. Then the old, okay, there's another one from the SCA, Lashman and others concerning Bosaso African Global. Yes, you'll get a list. I see there's I'll send this, I will update it and send it in due course. It's not going to be shortly. It's been developed for the intensive course, but I will share it with you at a later stage through the channels at LEAD. The last one that I want to refer you is the one that came out in 10th of May 2022, Lashman and others versus African Global. That one concerns the suspension of liquidation proceedings. The summary basically says Section 1316 provides for the suspension of liquidation proceedings at the time of business rescue application is made. Meaning of when business rescue is made, it says business rescue application must be issued, set by the sheriff on the company and the commission, and each affected person must be notified of the application in the prescribed manner, so to meet the requirement in Section 1316 in order to trigger the suspension of the liquidation proceedings. So as to when business rescue application is made, you've got to comply with this. As I've undertaken, I will provide you with these cases, a list of them, and the summaries in due course. It will be more than what I've mentioned because I'll just merely summarize. And then obviously that we've come to an end. Are there any questions before we wrap up? Yes, go ahead. I think it's, let me see who it is.
Claudia.
Sorry. Oh, yes.
Claudia.
Yes, sorry, I've been jumping you. Your hand has been up all along. Let me hear. Claudia?
She has been unmuted.
Okay.
She has been unmuted. I'm not sure why she can't ask her question.
Claudia, are you able to talk? Maybe it's another. Okay, she seems muted now. Unmute yourself, please, Claudia. Let's see. Yes, go ahead. Because from our side, you are unmuted. Can you check that maybe? What else? Claudia, can you write something to me? Just to indicate whether you're still here. Otherwise, you're the only one that has got your hand up. Anybody who's got their hand up? Then Claudia might have to, if you can hear me, through lead, you can ask me a question. It will reach me and then I'll respond. Sorry that we have to do it that way, but we are obviously out of time. That applies to anybody who's got a question. If you ask a question, then I will respond to it, including the questions in the chat box. I will respond to those perhaps over the weekend, and then furnish those answers to lead to distribute, or else they might be distributed at a later stage together with the material that's going to be distributed. Perhaps that is a better approach than at once.
Sir, Rurik has typed an answer on the chat function. So I'm not sure, I mean a question. I'm not sure if you're able to see it.
I saw something coming in. Yeah, Rurik, can someone be sequestrated and then nothing happens? Rurik, firstly, let's use the terms the way I said we using them. Let's change the rephrase and say, can someone's estate be sequestrated? In other words, can someone be declared insolvent and then nothing happens? The sequestrator has supposedly appointed a trustee. Now the master appoints a trustee. The sequestrator nominates a trustee, and nothing has happened since 3 years. In this case, an application be made to the court for rehabilitation. And if so, what the grounds be for the liquidation? There is no L&D, absolutely nothing. You can basically, probably what you need to do is to try and find out with the master as to what is the correct position, Rurik. And then if no claims have been proven, if you're aware of that, then you can use that angle. But if what you'll probably need to do first is to send a detailed list of questions to the trustee. If you're not aware of the trustee, you will probably need to approach the master to find out the details of the trustee. Then you pose specific questions to the trustee